Log back in again, see if that works.
Cool.
Right, we're back up and running, but let's just give it a couple of minutes. Just whoever we just lost. I don't know what was going on there. I genuinely haven't done anything. Right, let me just get the usual blurb back up into the video, and let's see who we're missing. Right. Well, whilst we're just waiting, anyone got any gossip? Just whilst I'm sorting this out. You had a good week, guys?
Yeah. I lost my big court case in front of Jan Luber.
And has he quit now?
I think he's quitting tomorrow is his date. But
was it like did you feel like it was did you get why it wasn't successful, or was it just unlucky?
Well, it's always a bit like reading tea leaves, or playing poker, because I think that if we'd won, it would have been quite a significant, wider public sort of issue. And I think he felt it was a bit above his station to make that decision. So he was making the sort of conservative decision against us. But sort of, I think he did it in such a way that it would be very easy for us to appeal. And I think he was sort of saying, well, I can't make this order that you want, but go ahead and appeal it, and maybe they will. I'm thinking that's what he was doing. He'd probably deny that. He'd probably say, no, you just had a rotten case. But yeah, it was a bit of a surprise, but it'd be interesting to see where it goes on appeal.
Do you think so you intending to take it to appeal?
Oh, definitely. Yeah. It's because he left too many doors open for us not to, really, and it's really important. I mean, the big issue in the case is where if you want to evict a disabled person who's mentally ill, you've got to demonstrate that you've done everything possible less than evicting them to achieve the same outcome. And that includes referring them to social services. But if you just sort of ring up social services and make a sort of lackluster referral, or you see that social services are doing a terrible job and you don't challenge it, is that enough? And we say no, otherwise there's no protection. But the problem was the social workers that came to court were, I don't know if I'm live on this yet, they were so bad. So you could sort of sympathise with the landlord. Oh, that's my son.
There's
We've got
one back.
Hold on, what's going on now? Shannon, say something. What's going on with us?
You had frozen for like a few seconds,
okay.
But it's fine. You're back again.
Okay, right. Well, sorry about that. For anyone trying to work out what's going on, I ain't got a clue what's going on either. But we appear to be on YouTube again now. Hopefully, we haven't lost too many people there. We've got just 2 questions that come in through the week. Let me just do the usual blurb. So this is not legal advice. Please don't share personal data in the chat. Just ask questions as if they're about someone else or someone hypothetical, even better. We actually had a really good example of that came in during the week. I'll read it out in a bit. Welcome to anyone, any regulars. Nice to see. If you want to say hello, feel free. I don't know who we got in tonight. Other than that, I don't know. I am just going to share my screen with something I've been working on. I just thought it might be of interest to people. So I've been doing a bit of stats this week because I had a nightmare week that nothing went to plan on, as this live stream has also proved. And now I can't. Here we are. What's going on here? So yeah, so this is let me get the right one here. So this is basically, if I zoom in a little bit, this is all the upheld LGO decisions in the last like 3 or 4 years. I've just went through the whole lot basically. I don't know how well you can see that, but yeah. So you've got like all these one in the middle are all London ones. So you can see basically London probably accounts for like more than half of the total complaints out there. But I'm just doing a little bit of kind of analysis. So Birmingham's also kind of high up there. Just doing a bit of analysis based on this and just looking at the correlation between legal aid deserts where they have no kind of legal aid funded services at all. So here's a list of them here. I mean, I guess people can pause it and have a look at it in more detail. So that's all the legal aid deserts in the country, and there's only a handful of complaints that ever got upheld from those areas. So as I say, I'll probably talk about that a bit more next week, but I just thought it might be of interest to people, see where your council scores on all that sort of stuff. It took me ages to dig it all out. So anyway, right, let's get to the chat. So we've got a question coming already. So two people were given private accommodation a few months ago, an elderly man and his son. They are unhappy with the place due to damp and mold, overcrowding, and not being able to pay rent. So my guess here is that there's a couple of things that you want to do. In terms of the damp and mold, raise it with environmental health, because unless it's having a significant impact on your health, it's not going to be something relevant to homelessness. But in terms of the affordability, which we can also talk about a little bit this week as well, I had a bit of news about affordability this week. But in terms of affordability, you might be able to basically show the council that you're homeless and therefore be able to make a homeless application. The bit of news I had about affordability this week is that up until the autumn, there was an organisation called Association of Housing Advice Services, AHAS, and they publish regular research on how much stuff should cost, basically. And councils would use those figures to work out if you could afford your rent or not. Now, AHAS ceased to exist. I'm not quite sure why. And then Housing Reviews Limited took on that mantle. So Housing Reviews Limited basically do reviews for councils. And without saying anything about Housing Reviews Limited per se, it's not good business to kind of not uphold council decisions if you want to make a living, basically. So I saw some of the figures and I saw some of the advice to councils about it all. And I'm not quite sure legally whether I can share screen, so I'm not going to yet. But basically, there's some stuff in there which is like things like housing officers need to work out how much pocket money someone should have and stuff like that. It's like I'm not sure that's a council officer's job to do that anyway. So we'll probably talk more about that next time as well. But yeah, basically, it means we're still kind of in this limbo with affordability, not really having anything kind of clear figures, because the courts kind of say, well, reasonable living costs, but as Wills have said plenty of times before, that word reasonable within the legal system could mean anything. So it's very difficult to kind of have black and white kind of guidance, but I'm hoping we can kind of put some stuff together at some point soon. We should give a bit more kind of helpful advice around that. So yeah, and then overcrowding as well. Overcrowding, unless it's having a significant impact on your well-being, it's not going to mean that you're homeless, basically. So you can certainly apply to your local housing registry if you're in that situation, but you might not get a house for many years. And other than that, as I say, deal with the other issues as best you can. But it doesn't sound to me like what's the best chance I think there of kind of being able to make a homeless application is through affordability. You're going to struggle to do it through damp and mold and overcrowding. So yeah, that's my view on that. Do you want to fill anything in there, guys? Have I missed anything?
No.
Cool. So right, let's go to the questions that come in through the week. Now, this is the first one. Is a good example of a question because they basically pin down exactly what they want to know rather than kind of giving way more information than we need to kind of actually give a sensible answer. So the question is, please could you explain again the difference of being dealt with under Part 6 versus Part 7? After making a homeless application, a friend was already on the housing register. They weren't homeless. Recently, they became homeless. They made a homeless application to the council, was assessed as homeless, and the relief duty kicked in. Can they ask to be dealt with under Part 6, or is it too late? What would this entail? Should they agree to a personalised housing plan, or can they just stay on the housing register now as homeless? They don't want to be forced to accept a one offer, probably out of the area. So yeah, that's the question. Really good question. So let me explain or unpick a little bit of that before we start going into it. So within the Housing Act 1996, which is what we're always really talking about here, there's two parts that you want to know about. One is Part 6, which is the rules around housing registers. And the rules are councils can set their own policies, which is why every council has a different policy pretty much. But then Part 7 is everything to do with homelessness. And that's the same across England. So they can't kind of set local policies around that, although the two parts do interact. Now, again, this person's obviously watched the videos because they've kind of been paying attention. If you approach any department of a local authority and you ask them for help with housing and you give the council reason to believe you might be homeless, you automatically trigger a homeless application, whether you know it or not, whether the council knows it or not, whether the officer dealing with it knows it or not. So they should therefore treat it as a Part 7 application, which basically means that they might have a duty to provide interim temporary accommodation. Whereas if you just stayed on Part 6, you wouldn't have, there would be no duty to provide interim accommodation. Now, this often crops up with domestic abuse because people experiencing domestic abuse join the housing register. They tell the council they're experiencing domestic abuse, but the council don't recognise that they're actually legally homeless, and so they just leave them for years at risk of abuse, and can lead to some very serious failures. So yeah, essentially what should happen is as soon as the council's got some sort of information that says they might be homeless, they should therefore take it down the Part 7 track. Now, the downside of doing that is that although there's kind of these immediate duties to provide interim accommodation, as this person's correctly noticed, you could well end up with much less choice when it actually comes to bidding, because under Part 7, and again, councils have different policies depending where you are, but under Part 7, basically the council wants you to get housed as soon as possible. They don't want you to pick and choose. So therefore, they will either give you no choice at all, really, or they'll give you one bidding round to have a go and you'll fail that one, but then they'll just basically put you on auto bid, or they'll just make you bid basically on anything that comes up, which is understandable from the council's point of view. So the question in that context is basically, can you insist to stay under Part 6? Now, this might be something that you'd be able to do if you were staying short term with friends and family or something like that, and you're kind of content with that arrangement. The benefit being that as you stay under Part 6, you might then get more choice about where you end up living. So I'm hoping that makes sense so far. You can, and I've only done this. This has only come up once in my casework. You can insist that the Part 7 application basically isn't triggered, and you go back to Part 6. Now, I dug out the case for this. So this is an old edition of the Housing Law Casebook. So it's RV Islington LBC XBP, which means something to someone out there. It's from 1998, and it's actually a case which is asking the question: is an application for a transfer, would that trigger a homeless application? The answer is yes, it would. But it gives the wording here. It basically says, a part, a Part 6 application that gives the council reason he might be homeless should be treated as a Part 7 application unless the individual expressly indicates that such consideration should not be given. So the homeless applicant can effectively say, I don't want to be dealt with under Part 7, I want to remain under Part 6. Any sensible council would say, fair enough, that means we'd have to provide temporary accommodation, let us know if anything changes, and everyone wins. That's kind of, how things could work out anyway. So in terms of, engaging with the personalised housing plan, if it was me in that situation, I'd go to the housing officer and say, hang on a minute, this person doesn't want to be dealt with under Part 7 at all. They want to remain under Part 6. They're already on the housing register. They're already on Band B or whatever it would be. Are you okay with that? And as I say, any sensible housing officer should probably say, yeah, that's fine. That kind of suits us and it suits them. So, yeah, that's my answer. Does anyone else, do you guys want to add anything into that at all? Does that make sense?
Yeah. Could you just clarify what the name of that case was? Did you say ex parte P or
B for Bravo. So
oh, B for Bravo. Okay.
I don't know if this is going to pick it up. Is this top left one up there? I don't know if you can see that or not.
I was just
I get there's a code as well. So 30, that's 30 HLR 706 Queen's Bench Division. I don't know what that means, but that's something. I can send you that. Oh, go on, Shannon.
Yeah, so it's been a long day. My brain, just bear with me because my brain's not quite working tonight. But there'd be no chance that if they sort of denied the Part 7 application and went down the Part 6, say in 6 months' time, they still, haven't successfully bidded and got a place. And then they were like, right, I'll go down the Part 7 route because it's quicker and stuff the out of area and what have you. There's no way that they could be deemed intentionally homeless because of that, because they've refused help. It's like, they've made an intentional refusal of help 6 months ago.
No, I think it'd be the same thing as, you wouldn't be intentionally homeless if you lost interim accommodation, because I guess they could see it in that
Cool.
sort of way. But so no, I mean, I think it would be something you want to agree with your housing officer in writing first before you do it. And I'm sure there are some housing officers out there who either don't know about this or are going to be difficult. But as I say, most housing officers I would have thought would be like, yeah, fair enough, that's great, because we don't have to provide interim accommodation for you. We can effectively do no extra work. You're already on the register, and kind of wait for that to kind of go through. So, hey, right, Nick. I've just seen sorry, just got back onto the live chat now. Sorry about the mess at the beginning. Hopefully everyone's here now. So yeah, and just a question on that, just the question coming there, what is interim accommodation? So um, interim accommodation, a lot of councils or a lot of people talk about emergency accommodation, but emergency accommodation is not a legal term. Emergency accommodation is interim accommodation, and the reason it's called interim accommodation is it's the accommodation that's given to you between making the homeless application and giving the council reason to believe you might be homeless, might be eligible, might be in priority needs, and then reaching a final decision, which could be 2 or 3 or 4 months down the line. So it's called interim because it's in that period where you just don't know what is actually going to happen yet. Once the council reaches a positive decision, Section 184, and they accept a duty under Section 193, which is the main housing duty. I'm using a lot of jargon here, so I apologise. You might still be in the same address, but it becomes temporary accommodation technically, if you want to use the jargon of the sector. So, and you could remain in that temporary accommodation for many years before you actually win a bid or get housed in the private rented sector by the council. But that's what we mean. So it could be a B&B, it could be a flat, it could be a hostel if you're in an unfortunate part of the country. So yeah, hopefully that answers that question. So have we dealt with that question? Anyone got any more things to say about that last one? Or we okay with that?
Or the part 6 or the interim?
The part 6 one, yeah. Yeah, anyone want to return to that at all? I know it's a quite big complicated one.
I think I've talked about my views on it before, which is that it causes me so many headaches, and it's very difficult for the public. But the problem is now that it's part 6 is so much of a lottery. I mean, part 6, I mean, by will you get social housing as a result of applying as homeless? Because I had a case, I've been helping a guy in applying to Hammersmith Council for about the last year, and initially they said he wasn't priority need, and we reviewed it and thought it. They accepted a duty to him, and then they sent him a letter telling him, unusually, because most councils don't do this, they then sent him a letter saying what his status was for part 6 purposes, and he was in band 3. So we were about to sort of try and challenge that, but then he sent me a message saying, oh, they offered me a council flat last week and I've taken it. And I thought, well, I never thought that would happen. And then other people, they apply and they get offered private sector accommodation north of, Manchester or something, and then it just no method to it really. So all I can say is if you're applying, if you're in a home, my advice to people is if you're homeless and you really can't go on living where you are and you simply haven't got anywhere, you can't really cut your nose off to spite your face. Well, you can if you want, but I wouldn't advise it of saying, well, I'll go on suffering because I might get a council flat at the end of it. You really just have to accept that it's the part 7, the emergency accommodation route is there to sort of give you a safety net, but don't have any illusions about. I mean, you can apply for part 6 at the same time, and you might get something, but don't expect it. But I mean, I wouldn't. To answer the question, should you wait? If you are homeless and you're in a situation which is unreasonable for you to continue to occupy, I mean, the longer you wait, the more unpleasant your life is. I mean, it could be quite a serious mistake to make. But then again, if you really want to get a council place, I mean, I wouldn't want to stop you doing it, but it's just difficult, and there's no legal sort of provision that can say, well, you've been waiting this long, you must get a place. And I've got to try and do a challenge. Sorry to go on, but I'm somebody who's in a council flat at the moment, which is unsuitable for her because of her medical condition. She really wants a transfer to another council place, but they're saying you can't have a transfer because that's an allocation under part 6, and we're not going to put you high enough to get one, but we'll give you a private sector place. And she's saying, well, of course I'm not going to accept that because I'm going to lose a council place. So I've got to look into them. That's why we're trying to get the name of that case, because that might be a starting point. Because does that mean council tenants can't get a transfer anymore and they just join the wider queue?
I mean, so the I'm not going to be able to give you an answer, but Doughty Street Chambers did a conference on domestic abuse, like maybe a year or two ago, and I watched it recently, and they did a whole section about transfers and how actually there are avenues of challenging things, and they kind of gave it in the context of domestic abuse, where a victim of domestic abuse might effectively lose their social housing status because of the abuse, because they then end up in private rented. And so Doughty Street were basically saying there are some kind of challenges you can put in to make the council consider a transfer, but I can't remember the ins and outs of it. But yeah, I can send you the name of that case. I mean, the reason it's a really obscure case. The reason I did, because back when we started complaining to Bedford Borough Council, this was like 2015, and they first. So I kept making this point: when someone approaches the council and tells you they might be homeless, that's the application made, and they just wouldn't accept it. Then they did accept it, and they put a little tick box in their form, which basically said, "I've chosen not to make a homeless application." And they just tell people, just say, "Oh yeah, there's no point in you making an application. You're okay if I just tick this box." So I then had to complain about that, and I said, if you're going to turn down that option, you have to give it, expressly. You need to really know what you're talking about. You need to know why it is you're turning it down. Now, the person that's asking this question, I would say that's a sensible kind of question to be asking. What they end up doing is down to them. But for most people who are obviously desperate, they do want to be making a Part 7 application. They don't want to be turning that down. So, yeah, cool. Right, so back to the live chat for a second. Some are sofa surfing after being kicked out of the family home. The job coach has done a duty to refer over a month ago, and she tried to contact the council nearly every day since. What should the person do? Well, okay, so we said this before as well. This is one of the main problems with the Homelessness Reduction Act. The duty to refer does not trigger a homeless application. So although the job centre staff has done it, and that's their job to do it, you haven't actually triggered a homeless application yet. So what the person needs to do is send an email. I'm going to do a video about this, by the way, on the main channel, like a recorded one. So if it was me, I'd find out which council I want to apply to, first of all. It's sometimes obvious, but sometimes less obvious. And then I want to find the local politicians who are relevant to me in that situation. So it might be my local ward councillor, it might be the one who deals with the housing portfolio, MP, whoever else, and send an email to the council and say, this is a homeless application, but copy in those relevant politicians and basically say, and if it was me, I'd quote 18.5 of the Code of Guidance before I even started and said, I can make this application via email. That's what the Code of Guidance says. And then I'd lay out my case. So in this situation, I would basically act as if the duty to refer didn't happen, because they often don't result in anything useful happening at all, and trigger a homeless application via email by saying, I need the council's help. Please help me out. I'm homeless. That's what you need to do. Now, you still might get a housing officer that doesn't actually do anything then, but at least you're one step closer to kind of getting a response, because the duty to refer, the council can basically one bell you, say, oh, we tried and nothing happened, so we're going to put that one in the bin. Whereas if you trigger a homeless application, unless you don't have any contact with them for 56 days, they need to continue their inquiries. They can't shake off that duty nearly as easily. So that's why it's important to trigger a homeless application, not rely on the duty to refer form, because it doesn't actually do a whole lot. It's not got any teeth to it. So yeah. Anyone else want to say anything about that question there, guys, or shall I go on to the next? If the council accepts your homeless application, can they force you to take private rented accommodation? Yes, they can. As long as it's suitable, they can effectively force you, or force is the wrong word. They can discharge their duty by an offer of suitable private rented accommodation, and all us three would always say accept the offer and then challenge the suitability. Don't try and do it the other way around, because it's just playing chicken with the council. And that might mean moving 100 miles away or 200 miles away and then challenging it from there. Suitability is probably one of the harder things to be arguing. So I think it helps to have a solicitor on your side at that point, because there's limits to what someone like Shannon or me can do, because we're just lay people. whereas Will would be able to write angry letters to the legal department and kind of probably have a bit more to do in that
Yeah, but
situation.
I wouldn't have much of a hope if my argument was I've refused the private place because I want a social landlord, council or housing association. I wouldn't get very far with that challenge, unfortunately. Can I just go back to the one thing I would add to that last question about what should the person who's had the referral done by the job coach, and it says what should she do? I mean, is just I mean, they are acting unlawfully, and if they've actually contacted them every day since, it's arguable that those subsequent contacts were not duty to refers. And so, I mean, what you should do is send a message saying, "I am making a homeless application now, if there's any doubt," and then if you get a solicitor or somebody or to help you, you could write them a letter because it's just a classic bit of gatekeeping. They just don't do anything. And once I've got a standard letter I send to councils like that, just saying it looks like you haven't processed a homeless application, breach of section 184. You've got 14 days or less if necessary, and they'll back down every time on that because they know that they haven't got a leg to stand on. Whereas on the private sector one, they will the boot's on the other foot. Unfortunately, there's very little I could do.
Yeah, cool. Thanks, Will. Next question. If someone is already housed, getting universal credit and is facing a rent increase in private rent accommodation, can the council help if you approach them for homelessness assistance? Now, this comes back to what we were saying earlier about the affordability of the accommodation. So it's very, very possible that someone in receipt of universal credit will be legally homeless because they can't afford the kind of essential living kind of things like food and travel and stuff like that, as well as top up their rent. Now, the LHA, the local housing allowance, so how much you get from universal credit will be going up in 1 week time, 2 weeks time, quite significantly. So that probably worth just checking out, looking at your local council's website, or just search for your local council's name plus local housing allowance, and you should be told how much the universal credit is going up to. In some areas, they're kind of very significant increases, sort of 15 or 20%. So that might be enough. I don't know. But if you're objectively not able to kind of meet those essential living things and pay your rent, then yes, you can make a homeless application, and yes, the council can help you, and they'll probably do that by getting a discretionary housing payment through, and basically increasing your income. Unfortunately, it only lasts for 3 months or something, so you've got to keep doing it. But it's better than nothing. It's a bit of extra income. So yeah, again, anyone want to add anything to that?
Sorry, Shannon, you go
Oh,
ahead.
sorry. I'd just add, where it is the housing element of UC, it's always worth just popping it in your journal and just having like an honest chat with whoever's the other side of that and explaining the situation. There are a lot of things that the DWP can do to help that they don't necessarily advertise. But it's for times like this when you've got a rent increase or what have you. So it's really worth, single parent as well and unemployed and what have you, just being honest about the situation and asking, because I do think as a general rule, I'm not one of those people who's like, ask because you never know. But in this situation, ask because they might be able to have discretionary funds available on the UC front whilst you're waiting for sort of a DHP come through, or like Mike says, waiting for the LHA rates to be upped or the UC to be upped or whatever it might be, or to help with other costs. And then that frees you up to put some towards rent or, yeah.
Yeah, cool. Will, were you going to say something as well?
Yeah, I'm sorry if I was repeating what you were saying because I was just distracted a bit. But I would say to anyone who's experiencing problems with a rent increase that makes them worried that they can't afford to pay the rent, and that they're worried then that they may down the line lose the place and face intentional homelessness. At the first sort of worry, apply to the council for help and say that you're worried that you're going to lose your home and ask them to assist you under the prevention duty. Now, the prevention duty, some councils would say, well, it doesn't kick in until you've sort of got a notice or you're threatened with homelessness. But I think the Code of Guidance says there's a general power to provide assistance at any time in avoiding the loss of your home. And they can't just say, sorry, we don't help people until they're facing eviction. Damn, I knew that was going to happen.
So on that note, so there's I'm just bringing it up now. So the local government ombudsman, which is like CQC but for councils, so they kind of like monitor them and investigate complaints. Now there's one we use in the training that we do, which is basically it's a Folkestone case. Let me just find it. And it makes this point really well. It seems like a really boring case, but actually it's really interesting from that point of view. I'm trying to find it now. Here we go. So it's Folkestone High District Council, and it's basically this guy. He went to the council in November, and he didn't know what the legal definition of homelessness was. So he basically said, "Look, at this rate, I'm going to be evicted in February." And basically Folkestone said, "Yeah, come back in February. Then don't bother us now." But the LGO got involved and basically said, "Now, hang on a minute. The income that this guy had, Mr. L had." In November meant that he was already legally homeless, and it makes this point. It kind of says, so it shouldn't be about, kind of saying, oh, you're not threatened with homelessness yet. He actually already was legally homeless because he just couldn't meet the kind of those costs. So I'm just going to stick this. I'm going to stick the code of it in there. If you Google it, I'll put it in the live chat. If you Google this, you should find it. As I say, it seems really bland, but it's actually a really good case. I'm just putting that in there now, so you should get that. So there's a code. Oh, go on. Is it going to go? There we go. So it's code, it's 20010166. If you just Google that, you'll find it. But it just kind of makes that point just quite not. So lots of people approach the council and they're already legally homeless, but the council just don't pick up on it. Again, sorry if one of you guys already said this. If you apply for discretionary housing payment yourself, you might get knocked back because you haven't filled in the form right, or just because the person wasn't feeling very generous that day. But if you make a homeless application, then get the housing officer to do it for you, it's much more likely to be successful because the housing officer probably sits next to the DHP team and they just walk in there and say, "Oi, can you pay this, please? Because it's going to help us out." So you're basically motivating the council to work by making a homeless application because they can then get a positive status, say, "Hey, we prevented someone being homeless" or whatever, and so everyone wins. So where are we up to? So someone's asked a question about overcrowding, and there's a one-bedroom flat, 2 adults, 2 boys, and a 1-year-old girl. The boys are under 10 with damp and mold. I mean, you can make a homeless application. There's nothing to lose by doing that and make the argument that you're overcrowded. It's difficult. I mean, I just haven't had a lot of experience with these sorts of cases, and it's something where councils can legitimately compare your circumstances to the general conditions in the sector. So if you're in Tower Hamlets, where a lot of people tend to be, more people, not a lot of people necessarily, but more people tend to be overcrowded, the council can say, well, relative to the rest of the district, you're not particularly, not significantly different. Whereas if you're up in Northumberland, it might be a bit of a different test. So yeah, I'm not very confident with overcrowding and kind of how it really works out in practice. So I don't know if one of you guys want to say something about that.
I think it's difficult without knowing like the whole flat layout as well, because you've got like the room standard and the space standard. If you're going by the room standard, it is potential that they wouldn't be overcrowded if they've got a living room as well, for example, because the living room counts as a bedroom. The 2 adults are deemed, to share a room, and then because of the ages of the children, actually it's okay for them to share rooms, because the girl is only 1 and you then got the 2 older boys, but I think it's 11 that a male and a female sibling has to be separated, I think. So and like you say, then when you take all that into account and then you compare it to the local area, and if everyone else is actually overcrowded by 1 bedroom, then all of a sudden you're not technically overcrowded. I guess there's the argument to be made, like you said, about mold and damp, and if it's affecting your children's health or your health, then that's a different situation. You could be homeless because of that. And again, I guess if it was so overcrowded or untenable where it was affecting disabilities, then again that's a sort of a different conversation. But on its own, I'm not sure if it would be. But Will, I think you know a bit more than I do about this one. You're on mute.
You're on mute, Will. I'm sure what you're saying is great.
That doorbell meant I muted it. Yeah, I've been looking this up while we were talking, and I put links in the chat, which Mike, I think I can't post to the meaningful links to the thing. So if you could add those, I've put a little thing called the Overcrowding Guide, which is a summary of Part 10 of the Housing Act 1985, and I put a link to that. But the answer to the question, which is in this one, is would the people in this situation be overcrowded? And the answer is no, right? Because, oh yeah, sorry, the answer is just yes, because they've got a 1-bedroom flat. Now I'm assuming that's got a living room. So it's really a 2-bedroom flat because the living room's a sleeping room. You've got 2 adults, and the maximum number for a 2-bedroom flat is 3 people. Children under 1 don't count at all. Children up to 10 are half a person. So you've got a 4-year-old and an 8-year-old is 1 person. You've hit your 3, and then you've got 1-year-old, which is half a person. So you're half a person over the limit. But in practice, that's not going to mean that that sort of doors start opening, because the council just say, yes, technically you're overcrowded, but given the crisis in the area, we don't have to accept that. So you'd need to look at the impact which the overcrowding was having on the children particularly, and also whether the mold and damp is remediable. Because what they'll do is just they'll call the landlord up and say, you're going to fix the mold and damp. I had this the other week, and the landlord says yes. So they say, well, the landlord's fixing it, so that doesn't matter.
Yeah.
Sorry, somebody's just shouting in the background.
So, Will, I put the link of the Part 10 bit into the live stream chat. So that statutory overcrowding, people are just gonna have to Google that. So if you just Google statutory overcrowding guide, you should dig it out basically. So just give some more information on all this stuff. So are we good in that question? Yeah, should we move to the next one? Yeah, cool. So is it possible to be assessed as homeless in priority need and dealt with under Part 6? So hey, yes and no. If you go down the homeless application route down the Part 7 route, and let's say the council finds it has the main housing duty to you because you're in priority need, you may well then end back up on the Part 6 housing register. In effect, it's like a backdoor to the Part 6 register. But priority need itself is only a Part 7 term. Now, this is one of the many ways that this is really confusing, because Part 6 will also have terms like medical priority. They'll use that term priority in other ways, but it's not talking about priority need for the Part 7 definition. So it's difficult it's a sensible question. I'm not quite sure if I give a sensible answer to it. So in one sense, if you're not going down the Part 7 route, none of that kicks in. So if you've expressly told the council, I don't want to be dealt with under Part 7, even though I'm legally homeless, I want to be dealt with under Part 6 because I've already started the application process, but I want more choice. That's all very reasonable. So priority need wouldn't ever kick in, but priority on the banding, I don't know how to explain this without just sounding crazy, but on the banding scheme of your local council's housing allocation scheme, they will use that term priority. So, and if certain people got medical priority, they'll get an additional band or whatever, but it's not the same thing as priority need. So you could be in priority need and not have a medical priority, and you could have a medical priority and not be in priority need, if that even makes sense. So, but yeah, but basically, if you're sticking under Part 6, priority need doesn't kick in, but they will then be looking at the kind of priority banding system rather than priority need to work out what band you should be in, and it's different for every area. So there's not much more I can say about it, kind of on a live stream. But if you Google your council's name and housing allocation scheme, it will give you the policy. Most councils, it's pretty easy to find. And then if you open up the policy, it'd be like 30 or 50 pages long. Just look in the contents for where it says banding. It might be in an annex sometimes. Go down to that and you can see what banding is. And if you want to get really fancy, you can FOI, so you can make a freedom of information request to the council and ask them for their average waiting times in each band for each type of property. So that's free. You can do that. And they should really, if they were sensible, they publicise that stuff anyway. You'll get a rough understanding of how long you're going to wait if you go down that route. So, that question that someone asked before about, how would I make a homeless application? I would also, before I really start that process, if I could, I'd actually just Google what the average waiting times are to kind of make an informed decision about what to do. But yeah, again, we've already said homes application does not guarantee social housing. It could still be private rented. Yeah.
I guess it is still technically possible, because it's basically the question we first had via email was if you go down the Part 7 route and then withdraw the application, but you could have already had a priority decision made, but you've asked to be dealt with under Part 6, and like you said, housing officers are going to be like, yeah, cool, happy to deal with you under Part 6, but yeah, it's not going to have an effect on your Part 6 application, because like you said, yeah.
So if you're under Part 6, you will not get interim accommodation at all. So you won't get that offer of temporary accommodation. There is nothing in Part 6. That's why the difference is important. So there's just someone asking about, sorry I'm late, I hope I haven't missed my question about the eviction of a 30-year-old tenancy. I don't remember that question. I haven't seen that question, I don't think.
I think it came at the very end of last week.
We might do, yeah. Check out last week's recording, because I think it came in before last week's live stream.
I don't think we answered it, but he's put the if you notice, the question is there in the next question. He's expanded on it.
Yeah, okay. The 30-year-old tenancy ended because the previous landlord died. Only 2 months' notice. After 30 years, the new landlord and new owner. As I say, I'm. If you could just tell us where the further detail of that question is, and I'll try and dig it out. But as I said, it hasn't come up in this week's notifications from YouTube for me. So we'll just wait on that one. Next question: if you're homeless and you have been given temporary accommodation flat but refused on the housing register due to no local connection, what are your options with a baby? Okay, so oh man, this is another really good question. It's another one which is just insane because of the way they set the system up. So the term local connection, there is a Part 6 definition of local connection and a Part 7 definition of local connection, and they're different things, but they're called the same thing. So how is anyone supposed to know? Basically, Part 6 is likely to be very strict. So I use an example. So Hillingdon in London, you've got to have lived there for 10 years to get local connection under Part 6. But under Part 7, you only need to have lived there for 6 out of the last 12 months, or indeed not lived there at all if there are certain exemptions that apply. So you might apply to Hillingdon's Part 6 housing register on the online form. You're actually homeless, but they're too stupid to realise that. So they just basically treat it as a Part 6 application. And they say, well, you've only lived there for 9 years, so haha, you don't apply, we can't help you out. But what they should have done is they should have identified you're legally homeless, and therefore the Part 7 definition of local connection applies to you, which is 6 out of the last 12 months in settled accommodation, or 3 out of the last 5 years, or close family living in the area for 5 years, or permanent employment. And there are some other exemptions with that as well. So it's possible to have local connections in multiple districts at the same time, or none at all. And if you've got no local connection at all, then you can go anywhere you want. Or you might be fleeing abuse, and therefore you can go anywhere you want because you can't be referred back to your home area. So in terms of practically what you do in this situation is, and it's interesting here because you've been given temporary accommodation. So yeah, I mean, basically, if they've accepted that you meet the Section 188, which is the interim accommodation duty, then if they're saying you haven't got local connection, they're dealing with you under Part 7 at this stage. If they're saying you haven't got local connection, they should be referring you back, formally back to the area where you do have local connection. There shouldn't be the thing where they say, well, we're going to leave you in temporary accommodation because you've got no local. That doesn't work like that. Having said that, they could still just have an informal policy where they just put people in that situation into private rented, and you won't get a chance at getting social housing at all. But that's not how it should be done. Does that even make sense, guys? Can you just say whether what I just said, did that explain that properly?
Makes sense. Yeah.
They should be referred back to their area. If they've got no local connection under Part 7, and the council is treating it under Part 7 because they've given temporary accommodation, then they might be in the process of working out where they have local connection, in which case imminently you might get a referral back to wherever you are. And I guess just to highlight as well, if you're at risk in that area, you can't be referred back. And if you're being referred back because you have family in that area, but you don't positively want to live near them, you can also reject that referral as well. So yeah.
Yeah, so and this is another complication that came with the HRA, the Homelessness Reduction Act, is before the HRA came in, councils looked at local connection last, so you'd already been in TA for a few months by that stage, and then they could refer you back. But the HRA brought in the ability for councils to refer you back to your home area. By home area, we mean the area where you do have local connection and it's safe to be. Basically, much closer to the start of the process, but they don't have to, and they can choose to do it then, or they can actually still do it at the end of the process. Now, I don't know why councils would do it that way. But yeah, just to make this even more complicated, as I say, but basically, so councils don't have to look at local connection at all if they don't want to, but they will because they want to. But they should still be, as I say, they can't say, well, you've got no local connection, that's the end of it. It just never is. They need to, basically refer you back somewhere or act as if you have got local connection in effect. But yeah, so good question. Difficult to give a sensible answer, unfortunately, and as hard as we try, it's just the way it is. So yeah, hopefully there's something in there that was vaguely helpful. I'm just trying to think what else might be useful for that person in that situation. So yeah, I mean, I think pragmatically, if they've told you that they've refused you, make sure it's actually been given in writing, and just see if it actually gives some sort of explanation. And there should be a right of review, and it should explain it in the letter. Basically, if they're going to say that you've got no local connection, there should be a right to to review that decision, and it'll explain how you do it in that letter. And you can do that and basically say, I haven't got any local connection anywhere else. So what's the, what you're going to do? If you look in chapter 10 of the Code of Guidance, which you can download, Google it, Homelessness Code of Guidance, chapter 10 is all about local connection. And as Shannon said, particularly there's paragraphs 10.6 and 10.9, which are actually quite helpful, as well as the other stuff in there, just because they might give you some kind of little things to kind of go off.
Don't want to throw a spanner in the works. Where they've got child, and say like there's a co-parenting situation go on, and I'm not saying this is the situation, I'm just positing, because it's the household, if the child's dependent sort of father or mother, whichever parent it is, was in that area, they would have local connection to that area because it's family through the child, or not?
So I don't actually know. They used to, I mean, I don't know what the law actually says. I know councils used to say, oh, that's not, residence by choice, or, kind of it certainly used to be the fact that you wouldn't get local connection to your children, even if they lived in an area. Now, whether it would work the other way, I don't know. Will, do you know the answer to that question? How does local connection work around,
It's funny that you asked that,
parents?
because I had a case come up today where that situation exactly arose, where the father of the child lives in a different area, where the mother doesn't have a local connection. And I'm thinking, well, that must give rise to a local connection because the child has a local connection. But then again, if you look at the whole wording and the whole thrust of the definition, it tends to be limited to the adult applicant. But I'd like to look into that. But I was going to ask you if you knew I was going to ask that question myself, because until today, I've never come across it.
I'll stick it on my to-do list of things to figure out this week. Speaking of to-do list from last week, the question came up saying, can you give a non-priority decision to someone in the prevention duty? And I think the answer is no. I'm not 100% still yet, but I did a bit of reading into it, and I think the answer is no. Hey, Andrew, nice to have you here. So next question, is there a requirement to provide eviction notice and 5-year address history in the same borough before a homeless application can be accepted? Council replied asking for this as a condition. No, it can't. That's gatekeeping. So section 184, which is the gateway into housing assistance, which is why we call it gatekeeping if you prevent that. If you ask the council for help with housing and give them reasons to believe you might be homeless, you trigger the application there and then. It doesn't mention 5-year address history or ID or local connection or anything at all at that stage. So you can apply anywhere, in any way you want, as say 18.5 of the Code of Guidance. If you Google it, basically makes the point you can do it any way you want. And if you sensibly do it in an email. Now they can ask for that stuff, they can ask for it, but what they can't say is until you provide it, we are not going to do anything. That's gatekeeping. That's just illegal. But they will ask for that stuff, and they will want to know it fairly soon. But obviously there will be times when people just aren't able to do it. And as I say, you can't do it you can't insist on it as a prerequisite for making an application. That's not lawful. So if it was me, I'd just complain to the chief exec, even though it's something which is relatively minor, still complain, because it's just kind of, in every homeless application, or most homeless applications, you need to have you'll have a battle with the housing officer about something. And if you show the housing officer that you're willing to escalate it and take it to the chief exec, then generally you'll get treated better afterwards. So actually, it's not a bad idea to complain for that reason as well. So yeah, pragmatically you might say, well, just provide it and just let them keep going and then complain about it. But yeah, as I say, I would complain first if it was me.
Can I just say one thing on that?
Yeah.
Again, I think the theme of tonight for me is that the terminology that we have is very unhelpful, in that here we've got another term like we've got with temporary accommodation, local connection. They all mean more than one thing. Eviction notice. If the council are really saying you've got to provide an eviction notice before we'll process you, that is a classic piece of gatekeeping, in that they're doing the come and see us when you're evicted, but don't bother before. You've got to actually have a bailiff's warrant. But if the eviction, some people refer to an eviction notice being a notice of seeking possession, which is a common sense way of looking at it, because it does say you must leave on this date on most notices. But if the council are saying you've got to provide an eviction notice before we'll process your application, that's absolutely unlawful. But so that was the point I'd make there.
Guess just to add to that as well, gatekeeping is often really difficult to prove. But it sounds like actually this would be quite easy to prove, because you've already given them reason to believe that you might be homeless and that you've asked for help. And they've, in writing, I'm assuming, have asked, they've started their inquiries because they've asked for this paperwork. So they've already, you've triggered that homeless application and they've started their inquiries. So you've almost got the proof there to say, well, actually, you have gate kept me. I think, if I'm right in saying that, there's an LGO case where they started making investigations into the land registry. It reminded me of that, because they're going, well, we want to see your bank records and we want to see the notice and everything else. Well, if you're wanting to see that, you've got reason to believe I might be homeless, therefore the application's accepted.
Yeah, and in that case, it talks about it really succinctly, because it says, you kind of accept the duty first, then you make inquiries. I'll see if I've got it up here. I might be able to dig that one out as well. So I've just seen, so someone's just put a comment in there. They might be right, just talking about this local connection through, your kids, or rather than it being the applicant. I'm looking at chapter 10 of the Code of Guidance now, and it does, the language it does use is the applicant. Now, I guess when it comes to things like priority need, for most priority need characteristics, if someone in your house, so say for example pregnancy, if I'm in a homeless application but my wife is pregnant, I'm the applicant, she's part of my household, but I'm in priority need because she's part of the household. So you kind of got that sort of priority need through, kind of vicariously or whatever. It doesn't look like it applies to local connection in the same way. But it's, I mean, if you kind of go back to the spirit of the law and the letter of the law, clearly the point of having this local connection thing in there is that it kind of values family support. So I don't know, as I say, we might need to kind of just see if we can find any kind of clear kind of case studies on it or anything like that next week, and kind of come back. I think
there is a paragraph, isn't there, sort of talking about something like the local authority needs to be mindful of close connections that aren't sort of blood or in terms of support and care and whatnot. So potentially a co-parent might fall under that. But again, it's just how strong that is. Like, say, if there's case law to back it up. And
yes, it's not something I've read any cases about before, and actually, it's a good question. So we might, let's see if we can find. I meant to turn the AI on, but because I messed up whatever my order was going on, I've forgotten to do everything tonight. So, but I'm just trying to remind myself that we're going to look into that this week and see if we can find anything out that kind of gives that, kind of gives a bit of detail to that. Just so there's, so I'm not quite sure if I'm missing part of a wider question. The old landlord died. The new landlord just gave them 2 months' notice to leave. After 30 years, good tenants, no problems, just kicked out. I mean, if you're talking about Section 21, eviction process here, then yeah, you could have been a perfect tenant for 30 years, and the new landlord just doesn't, well, in fact, or the old landlord before they died could have just, at any point just issued a no fault eviction. They have to do it legally, so there's lots of things within that process they need to get right. But yeah, there's no security that you get just because you've been a really good tenant for 30 years. This is one of the big problems of landlordism in general. In that it's, landlords, for a landlord, your home is a commodity. For you, it's your actual home and you need it. But they don't care because it's not. There'll be times where it's just not business, so they just get rid of you.
I just
So
add a tiny bit to that. The thing that makes me work, because at the end of the question it says, "Is this legally allowed?" And what we're saying here is yes. But if the 2 months notice bit sounds like a notice of seeking possession, and then to just kick someone out after the 2 months is not lawful, because you have to get a possession order, and that would be an unlawful eviction. So, I mean, it sounds like from the question, it sounds like it's already happened. The past tense is used here. So it may be too late to do much about it, depending on how long ago it was. But if they've just kicked them out recently, I mean, we don't know if that notice was valid, because without going into too much detail, 30 years ago would be what, 1994, yeah? And the Housing Act 1998 came into effect in 1989. So the assured short-hold tenancies existed then, but there was a difference that in the 1990s, in order to have an assured short-hold tenancy, you had to serve a notice that it was an assured short-hold tenancy. Later on, they reversed that so that it was assured short-hold by default. And then if you served a notice that it was an assured tenancy, it took away the assured short-hold bit. So it could be there's a whole load of reasons why the tenant would be entitled to stay there, and that's what the court process is for. So I would say, I'm not saying that if it went to court, the judge would say, "Oh, it's 30 years old, you can stay." But it could be that if it was just a bit more than 30 years old, if it was like 35 years old, and it predates 1989, then it would be a Rent Act tenancy, and those are a bit harder to terminate. But I mean, at the end of the day, the fact that you've been there a long time doesn't mean you can stay there forever, usually, does it?
they've specified it's not a Section 21, and I wonder if
Ooh.
that might time with what you're talking about, Will. So
They've also specified that they've not left yet.
Oh, so they haven't been kicked out. Oh, good. Well, then the answer is it's not lawful for them to kick you out until they get a possession order, and there's no guarantee that they'll get a possession order, but you can stay put and wait and see what the court papers that they issue say, and then get legal representation. And you can go to court and see most county courts have duty solicitors that if you get there early enough on the possession day, or you could even be a little bit cheeky. I mean, maybe duty solicitors will tell me not to say this, but if you went there the week before your possession case, and so that they can see you when they finish seeing the people that they're seeing, they might be able to give you a bit of advice. So I would say stick with it, because you might have a defence there, but it's certainly not legal to kick you out after the 2 months notice expires.
and someone could ring up a court, assuming the court actually pick the phone up and just tell you which day the duty solicitor is going to be there, because they're not there every day, are they? They're kind of there certain days.
They usually list what the courts tend to do is stack up the possession cases on particular possession days, because they'll have the judge dealing with them will have about 20 cases, maybe more, because a lot of those tenants won't turn up. So all the judge does is says, "So case of Smith, anyone here for Smith?" And then Smith here. And if they say no and Smith's landlord's there, then it's sort of pretty much a rubber stamp, as long as the papers are in order. So you'd probably know that, like Wandsworth County Court, when I was a duty advisor, it always used to be every Wednesday would be the possession day.
Yeah.
But I wouldn't try and ring the court, because they won't. If anyone picks up, it will be somebody in the caller centre, unfortunately, unless you're very lucky.
Yeah. Okay. So there's one other question we had coming through the week, is actually in the Facebook group, but so when a tenant is evicted, what does the law say about his possessions left in the room regarding storage length of time to store, and the landlord contacting them to collect? So yeah, so I mean, at what point can a landlord just chuck all your stuff out onto the street? And I don't know the answer to this. I'm hoping that Will or Shannon
Oh,
does.
I do actually, but I didn't until just before this meeting started. I'm embarrassed to say I should do, and maybe I did, but I'd forgotten it. But tell me if I'm going into too much detail. But this raises the law that applies here is called bailment, and I think it's an old word, but which has its origins in when somebody's out on bail. It's the same thing but in this case, it means that when you become you are looking after somebody's belongings, and you would then have a responsibility. For instance, if you went into a cafe and you left your mobile phone in there, and you went back half an hour later, the owner couldn't say to you, "Oh, finders keepers, you left it here, I've sold it." And the same thing applies in eviction. It's called involuntary bailment. So you accidentally become, in fact, in the cafe case, it's involuntary as well. So you're looking after the stuff. Now, the law says that you've got to give them a reasonable chance to get the stuff out. So they say 21 days. And I looked this up. I can put a link. I found a firm of solicitors. But basically if you search for eviction and belongings on Google, you'll come up with I can't tell if there was two firms of solicitors that had articles on their websites. And basically the bottom line is you need to give the tenant notice that you've got their stuff if you're the landlord, and then you've got to give them a list of what you've got, and you've got to give them a reasonable time to get rid of it. So the question is, what's a reasonable time? Probably 21 days. More than that, less than that, you could be arguing, but 21 days is what they've said. And the thing is, a little catch there, if the landlord sells the stuff, then they have to give you the money, because they can't take advantage of being even if you owe them rent arrears. But they could, if they have to dispose of the stuff, deduct the cost of disposing of it, if you see what I mean. Although the fact to pay for disposing it, they're probably not going to have a lot of money. Sorry, you're going to say something, Shannon?
So again, I might be complicating things. So say that happens, the person's say in temporary accommodation, because obviously they've been evicted and whatnot. Does it cross over nicely with the sort of council's duty of protection of property? So like, would the council then be able to step in and be like, right, we're going to help you collect the stuff from the landlord, or would the landlord's duties supersede the local authorities, if that makes sense?
There's two separate sets of duties. The landlord's got a duty which is a sort of oldie common law duty of bailment, not to dispose of the stuff unreasonably, and not to make money out of it. And the council have got a duty to help store belongings. But it could, if you said to the landlord, I'm looking for, I'm trying to get the council to help me store my stuff, can I leave the stuff there? They'd have to say yes. But the thing is, it's a really grey area, because obviously the landlords are going to say, look, this happens quite a lot. And we get tenants who claim that when they were evicted, they had sort of 5 laptops and a mink coat and the grand piano in there. And really all that was in there was, a couple of pairs of jeans or something. So you need to make lists. Everybody involved needs to be making lists. If you've got stuff you can't get out of somewhere and you want to go back and get it, take photographs, make a list. Lawyers will always say when you're making claims, where's the receipts for when you bought it? But nobody actually keeps receipts for most things they buy. But then the landlord would have to make a list. And the question would be, if you've just evicted the tenant, how do you give them notice? Because they've gone, you don't know where they are. But nowadays, you probably would be able to email it to them. But if you'd really need to leave the notice in the window or on the, at the place where they got evicted from. So that's, I'll put the link in the chat there to there's a firm's Baring and Co solicitors have put an article on there about involuntary bailment and what to do, and that sets out all the stuff.
Would that apply to temporary accommodation as well? So where like you've been in your private sector leasing or something, and it happens a lot, doesn't it? Kind of the landlord just go in day 2 and just throw everything out. would this kind of protection be there for them for that situation as
Well,
well?
yeah, I mean, they would become an involuntary bailee if they said you can't go, you can't stay in the hotel, we're not letting you stay in here, and we're going to put all your stuff in bin bags and chuck it out on the street. They would then be liable to compensate you, because it would be a breach of their duty. I mean, duty isn't quite the right word with Ben, but I think, well, for the sake of this, it's not like a statutory duty, but they owe you a duty because they've got the stuff there, and they really got to give you a chance to get rid of it. But it's more about deliberately or recklessly damaging or destroying goods. That's the term that's used in the art. Oh, I haven't pressed send, sorry. Oh, yes, I have. Sorry, it's there. Yeah. So, yeah, it would apply to temporary. I'm glad I looked that up because, I mean, it doesn't happen that much. There's always or I mean, maybe it does, just people don't contact me about it. But there's always a suggestion that your stuff will just be chucked out if you don't get it. And the difficulty is, in order to enforce these rights, you'd have to go to the county court and make a claim. But I would have thought if you go to all the trouble of doing that, you'd probably win as long as you could prove it that you had the stuff. But that's half the problem is you probably don't have any proof.
It's one of those things as well that I feel like, do you know when you said you don't really see it often? I'm like, it's because everyone who's going through this sort of fight is so busy fighting like just the bare minimum that they're like, do you know what? Actually, I can deal with losing all of my belongings, and I don't have it in me to fight to, keep all of my possessions. So I'm just gonna, which is really depressing.
Yes, it
But
is.
yeah,
But that's the answer to the question, is it's not quite as bad as it seems legally, and practically it's very difficult because you've got to have, if you just go to court and say I had a whole load of stuff, you'll get some judge saying, well, yeah, I haven't seen a shred of evidence that you had anything. And I can't just take your word for it. So that's the thing is nowadays with mobile phones and things, maybe there's hope that people can sort of make a video showing what was in there, and photographs showing the labels of things.
Is there anything about like judges kind of just presuming that the tenant is lying when we know there's probably a lot more dodgy landlords out there than dodgy tenants? I mean, it just seems like they give the burden of proof on the tenant rather than a dodgy landlord. It just seems a bit unfair.
It is, but I think that's just the politics of the judiciary, really. I mean, they will generally, I mean, no disrespect to most of the judges out there, but the sympathy is generally with the property owning people, really, isn't it? Just like, I mean, I had this case I was talking about this week where the judge was absolutely laying into social workers, talking to them. I mean, I was cringing at how rude he was being to the social workers, and they had done a pretty bad job. But the housing association staff were just as bad, but he was being really nice to them. And it's, oh well, they've done everything you could expect them to do. And I thought, well, what's weird. I mean, the double standard there. So yeah, they are biased or inclined to, and also the problem as well, if you think about it, is the landlord will often have a lawyer, because they have the money to pay for them, and the lawyer will be saying to the judge, well, you can't find in favour of this guy because he hasn't given you any proof. So yeah, it's an uphill struggle.
Yeah. Okay. Well, I think we've got through all the questions. So thanks for the good questions. You guys here next week?
I'm around, yeah.
It's the Thursday before Easter, isn't it? If that makes a difference
I'm
to you.
away the Easter week, but I'm here next week.
Cool. Okay, guys. Well, yeah, I think other than that, we've got nothing else to say. Shannon and I are delivering training on our next open date is the 10th of May. So, yeah, with spaces to check out our Eventbrite for that. Other than that, keep the questions coming in. Yeah, and we'll try and do a bit of homework this week. So, I think local connection was one of the questions I need to go and find out about with family members. Was there anything else we needed to talk about? I can't remember now. Feels like that was the main one in my head anyway. But anyway, cool. Right. So, cheers, guys. We hope this